Welcome back to Good Law, Bad Law. On this episode, we continue our examination of what I believe is one of the most underappreciated issues of our day, the appointment of judges to the federal bench, and what some are calling President Trump's stacking of the federal bench with ideological extreme candidates. A few weeks ago, we had Grover Reese on, former Ronald Reagan administration judge picker, talking about this issue from the perspective of somebody who is pro-President Trump's efforts. On this episode, we have Aron, who's the president and founder of the Alliance for Justice, a liberal judicial watchdog organization in Washington, D.C. She has been on the front lines of every judicial nomination battle going back 35 years. We talk about what's happening with President Trump's nominees, why she's concerned about the quality of his nominees and the lasting legacy that President Trump is going to leave behind. You won't want to miss this episode of really important discussion on a very important topic. Thanks for listening. My guest today is Aron. She's the executive director of the Alliance for Justice in Washington, D.C. Nan, thank you so much for being on Good Law, Bad Law.
It's a treat to be with you. Thanks for inviting me.
You're welcome, and it's especially a treat. We were just talking offline before we got started. We're going to talk about a very serious topic today, judicial selection and President Trump and the Republican Senate. The efforts to get appointed and get confirmed through the process. A lot of judges, and I know people aren't paying all that close attention or as much as they should, but this is a hugely important issue we're going to talk about. But having you, Nan, on the program is especially a treat for me because as we were just reminiscing, you and I knew each other somewhat back in the days when I was a journalist in Washington, D.C. before I went to law school. And one of the things that I covered pretty regularly as part of my regular reporting was judicial selection. And we were just reminiscing about the Bork nomination, which kind of really opened the door in a way that we hadn't seen in a long, long time to just how important these confirmations are. And other names from the past, like Judge Ginsburg, whose nomination failed, and some other great stories that were in the news and on the front pages back in those days. So it was fun reminiscing with you, and I really appreciate you coming on to talk about this really important issue.
Wonderful.
So Nan, first of all, tell us a little bit of background about yourself and about the Alliance for Justice.
I formed Alliance for Justice in 1979 as an association or an alliance of civil rights and public interest organizations.
Wait, hang on one second. Hold on one.
Yeah.
All right, hold on one second. Hold on one second.
Sure.
I had a little bit of glitch here. So what do I do here?
I lost you halfway through what you were saying the first time. I don't know where it was. We're back on now.
I mean, should I start all over or?
I mean, it's up to you if you want to start completely over or just at that last part you were at.
I don't know what the last part I was at was, what that was.
Or we can just keep going from here and,
Well, we just lost this recording, and I'm not sure where we lost it, man. If it's okay with you, since we didn't get too deeply into it, I'm just going to start over.
Sure.
Is that okay?
Sure.
Okay.
Sounds great.
All right. Sorry about that. My guest today on Good Law, Bad Law is Aron. She is the executive director of the Alliance for Justice in Washington, D.C. So first of all, Nan, thank you so much for agreeing to come on Good Law, Bad Law.
Thank you. It's a treat to be with you.
And, as we were reminiscing just before we started, Nan, you and I knew each other, it's got to be 30 years ago when I was a reporter for the Legal Times in Washington. And I was covering the Justice Department and writing about judicial selection under President Reagan that's what we're going to be talking about today with regard to President Trump, his nominees to the federal bench. But back in those days, the people we were talking about were names like Robert Bork and Douglas Ginsburg and Antonin Scalia. And I knew you then as one of the authorities on this issue. So you have been uh, involved in this issue of judicial selection, a hugely important one, as long as I can recall. So uh, thanks for coming on to talk about this important issue. And why don't we start, if it's okay, give us a little background on yourself and on the Alliance for Justice. Help people understand what your organization is all about.
Sure. Alliance for Justice was formed in 1979 as an association or an alliance of public interest and civil rights organizations. Before founding the alliance, I was a litigator at the Equal Employment Opportunity Commission right out of law school. And after that, I worked at the American Civil Liberties Union at its National Prison Project, where I litigated cases involving conditions of confinement.
Mm-hmm.
In 1979, I thought it important to pull together progressive organizations in order to defend the gains and accomplishments that have been made in the courts by civil rights groups, public interest groups. And it just so happened that the founding of the Alliance coincided with the Reagan administration. So there was plenty of work to do to fend off assaults on public interest law from extremist lawyers and judges.
And yeah, go on. No, go ahead, because this became an issue under President Reagan and his Justice Department in a way that we hadn't seen in this country really for a lot of years, right?
I think that's right. I see it modern day court packing beginning with Ronald Reagan's second term. And that is because during his first term, he tried to get various pieces of legislation through Congress. For instance, he tried to eliminate the Legal Services Corporation. And yes, and not only Democrats in those years, this was the early 1980s, but not many, but several Republicans rose up and said to Reagan, no, we're not going to let you decimate the Legal Services Corporation.
That was a federal agency that provided public funding for legal services for those who couldn't afford legal services, right?
Exactly. President Reagan tried to block the reenactment of the Voting Rights Act, and again, a group of Democrats and a handful of Republicans came together to defeat that, and the Voting Rights Act was reauthorized. And many of his other legislative initiatives were defeated. So he made a decision at the end of his first term to turn his attention and put all his energies on court packing, as opposed to trying to get various pieces of legislation enacted through Congress. And so when he ran for his second term, he actually said in speeches, I'm going to put judges on the court who are opposed to abortion, in favor of school prayer, who are opposed to civil rights and affirmative action. And wherever he went, he spoke about transforming the federal courts, changing the landscape on the federal courts. And we took him seriously. It occurred to us on the progressive side that he really meant business. And we put together a project, an Alliance for Justice, of, again, civil rights lawyers, public interest lawyers, law professors, to embark on research, that is, researching candidates sent by the White House over to the Senate for federal judgeships. And we did that in order to raise awareness among progressive groups, among the senators and the press about Ronald Reagan's plans to reshape the face of the federal bench.
Well, and this was it was a move to make ideological the business of naming nominees, naming individuals to lifetime appointments on the federal bench, right? That's presidents, Republicans and Democrats always have nominated people they knew, or business associates, or people that they were comfortable with, or that a senator was comfortable with for one reason or another. There was nothing new about that. That's how judges become federal judges. They get named by the president, they get confirmed by the Senate. But what Reagan did, in a way, in an organized way that hadn't been done before to anywhere near the same degree, was really imposing an ideological approach to judicial selection, right? I mean, that's really what stands out in how he went about things, trying to legislate in a way which is kind of ironic given the judicial philosophy that he emphasized, but really to try to achieve change, social change, legal change, business law change through their appointments to the courts.
Well, that's right. What he couldn't accomplish through Congress, he sought to get done through the courts. And he figured, if I appoint judges who agree with my agenda, then we're pretty much ahead of the curve here. The other dynamic that had some influence on his reelection and his plans to reshape the judiciary is that the platform of the Republican Party, for the first time in history, actually called for the appointment of federal judges who subscribed to a particular litmus test. And again, that litmus test was anti-abortion, anti-civil rights, and in favor of prayer in school. And so when he was elected to the second term, he went about judicial appointments with a vengeance. And similar to, and Donald Trump is very much in Reagan's image, in the sense that wherever Donald Trump campaigned, he talked about the courts, and he had this mantra: if you love me, you have to vote for me. If you don't love me, you still have to vote for me, because it's about the Supreme Court.
Right.
And that's very intentional. It was intentional on Trump's part. It was intentional on Reagan's part. And
well, let me ask you about that then, because again, every president has to fill vacancies on the federal bench. That's part of the job. That's part of the executive branch function. And so we've laid a little bit of the historical backdrop here in talking about what happened during the Reagan years. And we're going to talk about the present, of course. We're going to talk about what President Trump is doing, how it's similar, how it's different. But we had a few presidents in between Reagan and Trump. So, you say Reagan stacked the courts. And I know from the Alliance for Justice literature that is a challenge that you're putting out there in terms of what President Trump is doing. How, I mean, did George H.W. Bush stack the courts? Did Bill Clinton stack the courts? Did Barack Obama stack the courts? What was different about those presidential years in terms of judicial selection than either what we saw during Ronald Reagan's time or what we're seeing presently?
so Republican presidents, and this isn't just Alliance for Justice's view, but that of court watchers, Republican presidents tend to put the true believers on the federal bench. And they do this for two reasons. One, Republican presidents want to make sure that their agenda is imposed, that their agenda is implemented. And not quite trusting Congress to do it, they know that if they appoint judges who have a hostility to civil rights, women's rights, workers' rights, they will, as courts hear cases, that their agenda will eventually take hold in many quarters too. And this is a very important point. Republican presidents, and that pertains to Reagan and George Bush Sr. and George W. Bush and Donald Trump, talk about judges and talk about courts because they know it plays very well with their base.
Mm-hmm.
Ever 1954 Brown versus Board of Education, when Americans, particularly in the South, began to, for the first time, put bumper stickers on their cars saying impeach Earl Warren, began to develop certain segments of the Republican Party a real hostility to the courts. And this hostility only grew with the courts ruling in Roe versus Wade. And so Republican presidents know that by speaking about the courts and by talking about court packing, they'll be able to galvanize the right-wing base of the Republican Party and encourage them to come out and vote.
So you get Brown v. Board of Education, the leading case that really kicks off the civil rights movement, 1957, I think, 1958, 1954. Whoops. And Roe v. Wade, this one I'll get right, in 1973. So then you get to the 80s, and I alluded to this earlier. You have this irony that Republicans in the Reagan era are advancing this idea with Justice Scalia as the leading proponent of judicial restraint, that that we're going to oppose judges who are faithful to the Constitution, who don't legislate from the bench. And the opposition to Roe v. Wade in ideological terms is claimed that you don't have a right spelled out in the Constitution to abortion, and yet you also you have this ideologically based campaign to put judges in place in these lifetime appointment positions on federal trial courts and federal courts of appeal, who are going to be seen as, or hopefully are going to be seen as, faithful to a certain agenda, a certain political agenda,
right,
a certain social agenda.
Right. Well, I think we have to understand, though, that the ultra-conservatives who refer to the term judicial restraint don't really mean it when they say that. After all, when you look at some of the decisions handed down by the ultra-conservatives on the Supreme Court, like Bush v. Gore, like Citizens United, like the Union case that they're currently considering, these cases are a far cry from judicial restraint and more resemble judicial activism than anything else. But having said that, Republican presidents and Republicans in the Senate, because as you say, after all, it's only the Senate that gets involved in the confirmation process, are very focused on packing the courts with judges who will carry out a certain program. Contrast that with Democratic presidents. President Clinton, President Obama. And what one sees from their appointments is, one, that the appointments are uniformly excellent, but two, most of President Obama's appointees were either prosecutors or corporate lawyers. And many people who say, oh, both sides do it, Democrats do it, Republicans do it, they need to look at the facts. And the facts are, I think that only 4 to 5% of President Obama's judges were public interest lawyers before they went to the bench. And the same is true with President Clinton. He tended to skew his judicial selection to moderates, and therefore the approach is different between
Mm-hmm.
Republican presidents and, on the other hand, Democrats, by and large, I can count on the fingers of one hand the number of Clinton or Obama judges who were abortion or anti-civil rights. But nevertheless, they are not the counterparts to the extremist right wingers that Republican presidents put on. They are much more moderate, much more middle of the road, but very good judges.
So when you say that Reagan's, pursued an agenda of stacking the courts, and now this is something that's being said of President Trump, there were only a finite number. There's a defined number of seats, so it's not like President Trump is adding more judges. What you're really saying is that his approach is to fill vacancies on the court with a certain kind of candidate, right? A candidate that they believe. And of course, once you get a lifetime appointment, who knows what direction you actually take as a judge. But they're certainly trying to put people on the federal bench who they believe will adhere to a certain agenda in terms of certain issues.
I would say the overwhelming number of Trump nominees have an exceptional level of hostility to the progress our country has made in terms of advancing civil rights, women's rights, workers' rights, public health protections. Their desire, as revealed in their records, which we copiously and thoroughly review, show a hostility, a antipathy to progress that's been made in this country. For instance, do you have a question? Then
go ahead. I'll give an example, and then we're going to talk about a bunch of examples. But no, go ahead and give the example you were going to make.
For instance, there's a nominee to a district court in North Carolina who is a protege and actually worked for Jesse Helms, enabling him to push ahead with voter suppression programs. There is a nominee to a seat on a district court in Louisiana who claims that contraception leads to people dying a violent death, who has written and said that that abortion is linked to breast cancer. There is a nominee who's now a judge on a circuit court who supported gay conversion therapy. You see in most, not all, but most of the records of the Trump nominees, this thread of extremism, of hostility, and what is so dangerous about what we're seeing is that while Donald Trump may be president 4 years, 8 years, these judges, as you said earlier, could sit on the court for 30 or 40 years. And in fact, most of the nominees being sent up to the Senate by the White House are in their 40s. Neil Gorsuch, who went to the Supreme Court, I think just recently turned 50.
Right.
So they will be sitting for many, many years, affecting our generation, the next generation.
Well, and I want to talk about some more specifics, Nan, but maybe we could start with some broader strokes here. And one of the things that you can do when talking about judicial nominees is you can actually look at some objective data. There are going to be politics. There are going to be certain political battles, some rising to the national level, as we saw in the confirmation of Robert Bork, as we saw in the nomination of Clarence Thomas, and of only really a few others. Mostly, this work gets done quietly, in the Senate, sometimes without even public hearings on these confirmations. But if you do look, there actually is objective data that you can look at and compare if you want to see how Trump's nominees are different. And there's been a report that just came out of the Senate Judiciary Committee by the minority members, by the Democrats, called "Republican Efforts to Stack Federal Courts." It's dated May 10th, and it's got a lot of data. The Alliance for Justice, your organization, on your website has a lot of very specific data on the qualifications of the nominees, on their positions as we understand them from their writings, from their judicial opinions, from their backgrounds. I mean, we can look at certain objective data and know that in President Trump's still very young presidency, he has more quickly nominated more people to the courts of appeal, which, as we know, in most cases, given how few cases actually make it to the U.S. Supreme Court, in most instances is the last stop in any dispute involving a limitless array of important issues. So he's appointed more judges more quickly to the courts of appeal. They are younger, they are more male, they are more white, and as you say, they have staked out positions in their in their life before nomination on a host of issues that suggests I don't even know what to call it. I mean, is this what we would call conservative nominees? Is this what we would call, I mean, I think you said, anti-civil rights nominees? I mean, how do you even characterize them as a group beyond some of the objective data that we can point to?
I certainly wouldn't call them conservative nominees, because I think we might all agree that conservative nominees, after all, there are hundreds, could be thousands of Republican lawyers who would make very fine judges, whom we might refer to as conservative. This word does not apply to the current crop of Trump judges. These are nominees who I would label, for the most part, as extremists. They have extreme views on abortion, on civil rights, on voter protection. You've got one nominee to the Fifth Circuit Court of Appeals from Texas that doesn't believe that EPA, the Environmental Protection Agency, or Department of Labor are legitimate. He will, if confirmed, this is Andrew Ullman, undermine environmental and public safety protection laws for a generation.
Right.
These are not people who are simply conservative, if only that were the standard, but these are people who are the culture warriors in terms of their views on some of the social issues, as well as people who denounce the administrative state, who are carbon copies of EPA Administrator Pruitt, who would do away with our agency structure, which is designed to protect health and safety, workers and consumers.
Well, right, and I mean, I think most people probably forget this, but the EPA was created under a Republican president, Richard Nixon, and now it is,
Right.
and now it is under attack. But this is the thing that I find so curious about this, because here we have a president, and I watched closely during the campaign in 2016, and I remember those Trump speeches where he talked about the Supreme Court, and he put out a list. And he said, this is the list for which I will choose. So he really put the issue of judicial selection, really toward the top of his agenda at speech after speech across the country. But it's such a curious thing, because in addition to all the things that are so curious about this president, he just has always struck me as not that political. um, Reagan was a known conservative in those days. Probably appropriately would call him conservative governor of California before he ran for president. Trump, if anything, was a Democrat before he decided to become a Republican. And yet,
Right.
as president, he is appointing, as you say, a crop of candidates to the federal bench. So where do you think this is happening in Washington? Is this something you think he himself is involved in, or is this coming out of the Justice Department under Attorney General Sessions? Where do you think the power is, so to speak, in terms of coming up with these names and these candidates?
Well, two responses. One, this president has shown an extraordinary level of disdain for the rule of law, for judges, for the great civil rights laws, environmental protection laws that undergird our democracy. So one would expect that a president who's been so disdainful of the law and judges would automatically resort to picking nominees who, in essence, are very extremist. But two, and equally important, this is a Republican Party program. Let's take a look at what happened right before the election with the nomination by President Barack Obama of Merrick Garland to the
Right.
Supreme Court.
He was not a raging liberal. He was not a raging liberal, by the way.
Very, Merrick Garland was highly respected jurist on the D.C. Circuit, but moderate. Mm-hmm. And President Obama nominated Merrick Garland, interestingly, in part because of a suggestion of Aron Hatch, Republican senator from Utah, who had voted for Merrick Garland for his seat on the D.C. Circuit. President Obama put forth a moderate with the hope that the Senate would confirm him. Lo and behold, Mitch McConnell went down to the floor of the Senate and announced that Merrick Garland would get neither a hearing nor a vote. This is unprecedented. This had never happened in any presidential administration. I remember the last year and a half of Ronald Reagan's second term, Ronald Reagan putting forth the nomination of Anthony Kennedy, a very conservative judge on the Ninth Circuit Court of Appeals, and the Democrats who were in power at that time gave him a hearing and confirmed him to the Supreme Court. What Mitch McConnell did was unconscionable, but not only did he stall any action on Merrick Garland, but he ensured that open seats would not be filled by Obama. And he did that out of the hope that a Republican president would be elected, and a Republican president could therefore take advantage of the obstructionism by filling all those seats, which is exactly what happened. So in part, this is Donald Trump, and in other part, it's the Republican Party who...
And the Republican Senate.
Republican Senate and Republican Party who went about this with a vengeance. And as you see now from articles in the newspapers, listening to Majority Leader Mitch McConnell and others, this is what they tout. This is their greatest accomplishment, is packing the courts and placing Neil Gorsuch on the Supreme Court.
So we can add a statistic to this, because this is taken from the report by the Senate Judiciary Committee that I mentioned earlier, that just came out a few days ago, and we'll actually post a link to this for people who want to read this. It's fascinating and chock full of data, objective data about this issue. But the first key finding by the Senate Judiciary Committee that produced this report speaks exactly to the point you're making, Nan, which is that not only did the Senate Republicans block Merrick Garland to keep open a seat on the Supreme Court for what they hoped would be the next Republican president. But they did so in the courts of appeals across the country and in the district courts. So you expect a certain number of vacancies in the federal judiciary when a new president takes office. But when President Obama took office, there were 53 vacancies in the federal judicial system. When Donald Trump took office, there were 112 vacancies, twice as many, representing 12% of the entire federal judiciary, just waiting for President Trump, to make his nominations and for a Republican Senate then to very quickly confirm. So, and they've done that, right? They have moved very quickly.
And the reason this is so important is that for everyday Americans, regardless of what your political preferences are, only really have the federal courts to seek some redress for problems and grievances. After all, you're kicked off Social Security. Chances are you can't go to your legislator unless you've given that legislator a campaign contribution. You certainly can't go to the federal government these days. So people turn to the federal courts as the forum, the arena where they might be able to get some kind of relief. And if you have judges and justices appointed, and with preconceived notions and ideas about who's worthy and who's not, makes it awfully difficult for everyday Americans, workers, people harmed by the environment, people being discriminated against in the workplace. Very difficult for people to get justice. So this is incredibly important because in our system, in our democracy, the courts are really the only available forum for everyday people.
Well, and I want to talk about some specific issues that are implicated by some of the specific nominees that President Trump has put forward. I have another question about the process that I'm interested in trying to understand, and that is, again, we have presidents nominating individuals to the federal bench every year. I mean, that's one of the important roles, one of the important responsibilities the president has. And there is a process. There's a process for nominating. There's a process for reviewing those nominees and for the Senate to fulfill its obligation to advise and consent and then confirm or not confirm a candidate. The American Bar Association, which is a non-political organization, the largest professional association for lawyers across the country, historically has had a role in the judicial selection and judicial confirmation process that is always in motion every month of every year. But President Trump did something with regard to the ABA in the judicial selection process that I think is significant. And can you speak to that? What he did and why that matters?
Well, President Trump, just like President George W. Bush, announced shortly after they took office that they would reject the ratings made by the American Bar Association on judicial nominees. In other words, they would ignore what the American Bar Association was doing. Interestingly, while they say that, when their own nominees get qualified ratings, they're the first to remind everyone that the American Bar Association gave them a qualified rating. But I think in terms of process issues, Aaron, a far more insidious thing has happened.
Okay.
And that is the Republicans, led by Mitch McConnell and Senate Judiciary Committee Chair Grassley, have broken with the tradition of using or resorting to the blue slip rule. And
well, I think probably many people don't even know what that is. Explain that, because it is important. I agree.
So the blue slip has been an essential component of the checks and balances of judicial selection. And when when the White House wants to nominate a particular candidate from a particular state, what happens is the White House will send literally a blue slip to the two home state senators with the agreement that if the senators do not turn in the blue slip, that nominee will not advance. If both home state senators do turn in the blue slip, that nominee will go on to have a hearing and a vote. This is a 100-year tradition in the Senate.
And that's regardless of political party? That's so
regardless, if you have,
yes.
Yeah. Yes. Regardless of president of parties. We saw, for instance, during the Obama years, when Patrick Leahy, Democrat from Vermont, chaired the Senate Judiciary Committee, his policy and practice was to respect a senator who did not send in his or her blue slip. And if the senator did not return a blue slip, Patrick Leahy would not give that nominee a hearing. That rule has been broken by the Senate Judiciary Committee. And we saw for the first time a nominee to the Court of Appeals in a Wisconsin seat be confirmed without the support of both home state senators. And by that I mean William Brennan, who was nominated for a seat on his circuit, did not receive the endorsement of Wisconsin Senator Tammy Baldwin. Mm-hmm. Nevertheless, Republican Grassley chaired his hearing, and a Republican Senate confirmed Brennan to the seat on the circuit. We also have a situation now. A nominee from the state of Oregon, a nominee to the Ninth Circuit Court of Appeals. Neither senator has turned in his blue slip, neither Wyden nor Merkley has turned in his blue slip on that candidate. And nevertheless, Grassley overlooked that, ignored that, and gave Ryan Bounds a hearing last week. And we're even seeing it in Pennsylvania, where the White House just nominated a candidate to the court over the objection of Senator Casey. So
we'll talk about the Ryan Bounds case for a little bit, because I think that may illustrate what we're talking about. Again, this is Ryan Bounds. He's a federal prosecutor in Oregon, and in fact, your organization, the Alliance for Justice, had a lot to do with uncovering some controversial writings that prosecutor Bounds authored when he was a college student at Stanford in the 90s. And I'll let you tell us about that. But the issue here, again, is a nominee to a very important court of appeals, the Ninth Circuit Court of Appeals on the West Coast. And you're saying both senators from his home state of Oregon withheld their blue slips, meaning they did not, in a sense, give their blessing for the nomination to proceed. They withheld their blue slips. And the Senate Judiciary Committee said, never mind, we're going ahead anyway, breaking with this tradition that you said has been in place for 100 years, whether the blue slip was in the hands of a Republican senator or a Democratic senator, whether that senator was in the majority or in the minority in the Senate. That's been the tradition for a long, long time. I mean, tell us a little bit about Ryan Bounds, because I know the Alliance for Justice played a big part in this candidate, and in this is very fresh news. It's happening right now. So give us a little bit more of the background there, please.
Sure. Well, Ryan Bounce had his hearing last week before the Senate Judiciary Committee, and understandably, many of the senators inquired into his views expressed in writings. In his college writings, and he, without going into tremendous detail, his writings represented an attitude of not just dislike or hostility, but they were hateful with respect to people of color, women, the LGBTQ Americans. I mean, absolutely hateful.
In one article, Nan, I know he compared certain racially oriented or campus organizations at Stanford to Nazis.
Yeah, yes, exactly. And interestingly, a commission set up by the Oregon senators approved of Ryan Bounce, but they had no idea these writings existed, and Ryan Bounce never explicitly shared the writings with the commission. So Bounce was nominated, and these articles and memos and writings appeared and were so disturbing that the commission in Oregon that originally approved him decided, 5 members of that commission decided to withhold their approval with great dismay over what he had written. Senators on the Judiciary Committee were quite upset with what he had written. His excuse was, "Oh my goodness, I was in college. That was such a long time ago." But one, of course, he's got to be responsible for a record, and that record has to include writings, publications, articles, and they were very relevant to his frame of reference and to his views. Neither senator, after reviewing those writings, turned in their blue slip, but nevertheless, Grassley held the hearing last week, and his nomination it will be voted on by the Senate Judiciary Committee shortly. But that's an example of someone who's not conservative, but someone who really had some very out of the mainstream extremist views. And our position is putting someone on the federal bench who has a closed mind, who has very fixed views on life and on social issues and economic justice issues, is not really the kind of person we want sitting in judgment of all of us.
So just to be clear, I mean, people do vote for president, and one candidate wins. One party, as long as we have a two-party system, one party is going to win. One party is going to control the Senate that confirms judges. I mean, there is this process that takes place year in and year out, whether you have a Democrat or a Republican. I want to understand where you're coming from on this, because the president has an obligation to appoint judges, and the Senate has an obligation to vet judges and then confirm them or not confirm them if they're not qualified. Your objection isn't to the fact that Donald Trump, as the president, gets to pick candidates that he or his Justice Department and advisors believe should be appointed. Am I right? Because that's routine. That's just part of our system. That's part of our constitutional system. You're saying there's something about the kind of candidates this president is putting forth, not so much that he doesn't have a right to do it in the first place.
Look, that's absolutely right. Presidents have, under Article 2, Section 2, a constitutional task of appointing judges, and the Senate has an equal task to either approve or disapprove of the president's choice. Here we're seeing two two very basic things happening with the Trump administration. One, we've talked about the kinds of extremists that President Trump is putting on the bench, but two, we're also seeing, is evidenced by the disregard of the blue slip rule, an unconscionable naked power grab by the Republican Party, disregarding the rules, disregarding the norms that have enabled for years, for decades, all senators to advise on and consent to judicial nominees. And when all of this is said and done, this will only contribute to the further politicization of the process, because it means if we get a Democrat elected president next time or 2 terms, that president, because of what Republicans have done, may well disregard the blue slip. Republicans will be ruining the day that they threw overboard all these rules and norms that in order to push through their nominees as quickly as possible. I mean, that's in part what Sheldon Whitehouse, Democratic senator from Rhode Island, said last week. You guys, you're going to regret this when Democrats come into power. And I think we can all agree that this is not a healthy situation. It's not healthy for Republicans. It's not healthy for Democrats.
Well, let me ask you. Let me ask you about some of the specifics. Keep promising we're going to do that. We've talked about a few so far, but I'm looking at some of the materials from your website. You've got Howard Nielsen from Utah, who argued that a judge who is gay should recuse himself, and who defended those who supported Proposition 8 in California that would have banned same-sex marriage. This was before the Supreme Court stepped in the Obergefell case to establish same-sex marriage as a constitutional right. Stephen Gratz to the Eighth Circuit Court of Appeals, who in his career fought against same-sex marriage while he was Deputy Attorney General of Nebraska. A candidate to district court in Tennessee. Who,
and I
would, on and on and on. So, what's going on with what is going on with these nominees and coming out of this president?
Is a very dangerous phenomenon, and that is you have a situation where the Federal Society, Heritage Action, and some situations, some occasions, you've got the National Rifle Association making the appointments. And this president did something very unusual during the election. He basically said, I will seek out the opinions of the Heritage Foundation and the Federal Society. The Federal Society is a group of ultra right-wing lawyers, and send their suggestions, their suggested nominees over to the Senate. He basically outsourced the process of judicial selection to these 2 extremist organizations. That had never happened before by any president, as far as I know. The other interesting phenomenon we're seeing is some of these nominees, like Gratz, whom you just mentioned, who, for instance, supported gay conversion therapy. If this were the George W. Bush administration, George H.W. Bush, you would never have seen these candidates advance through the Senate. These views would be found disqualifying. with this president, with this White House counsel, Don McGahn, and with this Republican Senate, anything goes. Anything goes. And it's not just the social issues. It's not just abortion, LGBTQ rights, but it's hostility towards workers, towards the environment, towards public health, towards consumers. I mean, these are people who have for a lifetime made campaigns, had records of hostility. It's not just one instance of a bad speech, but their lives are marked by work to undermine constitutional protections.
Nan, Steve Bannon, while he was still in the White House, declared war on the administrative state. When I had Grover Reese, I used to know him as Rocky Reese back in the Reagan Justice Department years when he was, for a period of time, Reagan's chief judge picker. We had him on Good Law, Bad Law a few weeks ago, and he talked about the administrative state, opposition to administrative agencies. And as you said, their very right to exist and make rules and pass regulations on the environment, on drug safety, on workers' rights, and you name it, on and on and on. That this was really the judicial philosophy of the day, the way abortion was a litmus test in the Reagan years, that this is now become a sort of litmus test in the Trump era. Is there a legitimate ideological argument here that could form an orientation for those in the White House and in the Justice Department who are picking candidates for the federal bench, that this could be a way of looking at the way these candidates think, and that from Neil Gorsuch on down, that's what's guiding the administration's choices?
I certainly think their antipathy to administrative state is a very important criteria. And as you just mentioned, we certainly saw Supreme Court nominee, now Justice Neil Gorsuch, reveal a very strong hostility towards the role of agencies in protecting public health and safety. So this is certainly a stream, it's a theme that is carried out, is implemented, is used to define many of the nominees. And I would say also that this disparagement of the administrative state, of agencies, is a view that ought to worry not just liberals, progressives, but everyone, because Americans depend on our agencies for the quality of their air, quality of their water, protections in the workplace. It's agencies that help make the rules that end up protecting, preserving our democracy. And to have candidates confirmed to lifetime appointments who don't believe in agencies and don't believe in the legitimacy of agencies is very dangerous.
Well, Trump, I mean, one of the things Trump campaigned on was that we're an overregulated economy. I mean, he said we have too many regulations in this country, and if I'm president, I'm going to work to cut back on the extent to which our economy is regulated, meaning business. And that does mean things like the EPA and the and Federal Trade Commission and other agencies, we're calling them agencies, that through their rules and regulations do impose limits or guidelines or requirements on different aspects of the community of the economy. So he campaigned on that. He won. Now he's carrying out what he said he was going to do? I mean, what's wrong with that? Why doesn't he get to
So,
do that in your view?
so here's why this is so important. It's important because every year, every 4 years, we go and vote for a president, and too few of us take into account that this president has has awesome power to appoint federal judges who will be on the bench for life. Too few of us think about judges when we go into that voting booth and pull that lever. Most of us are focused on our own immediate lives, our own immediate problems, and not enough Americans appreciate the critical, important role that judges play. And I will say this, when you have a Republican running for office, as Trump did, he talked about the courts almost at every campaign stop. And he did this with one goal in mind. And that goal was to nurture and galvanize and get out to vote individuals who belong into the extreme right-wing base of the Republican Party. And that's why you heard Donald Trump talk about judges so much, because he knew if he'd do it, those voters would come out and enthusiastically vote for him. Hillary Clinton, by contrast, didn't talk about the courts very much, or the Supreme Court, or Merrick Garland. And for that matter, if you look back at the Democratic Convention, I was so disappointed that almost no one talked about the fact that here you had Merrick Garland, a Supreme Court candidate, being denied a seat by Republicans. No one in the Democratic Party discussed, Merrick Garland discussed the critical role of the Supreme Court or lower courts. And I think that was a huge mistake by the Democratic Party. One party really ignored the issue and the other talked about it nonstop. And that helped drive up the vote for the Republicans.
For sure. I think you're absolutely right about that. Now, we're recording this episode today. It's Tuesday, May 15th. We'll be posting this episode on Friday, as we do every week. But today in Pennsylvania, we are having our primary elections for Congress and for other and for a statewide office as well. This is election day in Pennsylvania, very important state with a lot of very important races taking place. Given what you've said, what do you and 30 plus years of experience that you've had on the forefront of every important judicial selection battle that we've seen, and all of the unsung and not talked about judicial battles as well. What do you think people ought to be focusing on in this regard as they go to the polls?
So two things. One, all of us need to understand the critical importance of the federal courts. Mitch McConnell and Donald Trump will cement a legacy with reshaped courts for 40 years. Our children and grandchildren's lives will be influenced, affected by what federal courts do. So it's so important, Aron, that you are focusing on the federal courts with your podcast. Secondly, we have to remember the president nominates and the Senate confirms. And therefore, when we think about elections, we need to appreciate much more than we currently do the fact that senators get very involved in the confirmation process. After all, they can deny a president his nominee. So when we're faced with Senate elections, which you will in Pennsylvania. Casey's up for re-election. Donald Trump will be up for election in a few years. People need to remember just how important the federal courts are. I'm pleased to say that Senator Casey has stood up for constitutional rights and constitutional principles, and that's to be greatly admired. But people, one, need to know what courts do, and two, take that knowledge and use it when they're going in to vote for presidents and for senators.
Well, and I'll just add my plug too on that issue, because I do believe in voting, and I do believe in this issue, and I mean I've also followed it very closely for as long as I've been a voter. The other thing that people have to do, and it sounds so simple to say, but we take it for granted every time. You have to vote. You have to vote. More people didn't vote in 2016 than did vote. And sitting on the sidelines when the federal judiciary is at stake, wherever you're coming from on the issue, is really giving up an opportunity to have your voice count. So I add my voice to that. People need to vote. It's that simple.
Amen.
Nan, thank you so much. It's been a real pleasure to catch up with you, to reconnect with you, and to talk with you about this really important issue. You and I both agree on the importance of this issue to the future of our country. So thank you so much for giving me your time and for being on Good Law, Bad Law. Thanks so much.
And thank you for doing this. It's so important.
Appreciate it. Great to talk with you.